So this session is going to be about the Supreme Court of the United States, often abbreviated as SCOTUS. A lot of what I'm saying is going to be very specific to the United States Supreme Court, as opposed to other high courts, which will have other processes of nominations, other histories, other judicial powers. However, the structures of what I'm going to be talking about can usually be applied to debates about the highest court in the land in a whole number of contexts, and occasionally I'll be highlighting the differences between the Supreme Court of the United States versus other courts. If anybody has any questions while we're going on, feel free to just put them into the chat or interject them. There's going to be a lot of matter in this session, but hopefully we'll get through it and be very good. So, in terms of the Supreme Court of the United States, what sort of topics are we talking about? What topics generally come up? It's worth noting that topics about the Supreme Court are very common whenever there is an election year, but are going to be especially common after the recent death of Justice Ruth Bader Ginsburg, the senior liberal justice on the court, who is likely to be replaced in the coming weeks by a conservative justice, and that's going to raise all sorts of questions about the process of appointing justices and the justice of Donald Trump making this decision, how it might change the balance of the court, all those sorts of things. So the sorts of topics we get are things like, how might we change the appointment process? Might we prefer judges to be directly elected to the Supreme Court as opposed to the current process of appointment, which I'll describe a bit later? Might we change the retirement process? At the moment, judges are appointed for life tenure. Might it be better for there to be a term limit or an age limit on justices of the United States Supreme Court? There might be topics about how we might change the decision-making process of the court itself, whether or not the court should be able to consider certain cases in certain ways, and there might be changes that might come to that. There might be specific upcoming cases, issues, or appointments, very relevant now, obviously, and there are also often active debates about how to use the courts. So something like, as a progressive group, we would use the Supreme Courts to push for change or attempt to get a case before the Supreme Court as a way in which we might advance our particular agenda. Supreme Court topics tend to be very, very example heavy. There is often a lot of terminology that is specific to the Supreme Court, a lot of names that you might need to know, a lot of cases that you might need to be at least passingly familiar with. I'm going to go into a lot of those examples in the latter half of this session, but it's important to remember with example heavy debates, two things. Firstly, the purpose of these examples and the purpose of learning about them is that you are comfortable enough to be able to focus on the not examples part of the debate. Because very often in example heavy debates, people contest examples but lose sight of the debate itself. Always remember, the best attack on an argument is on the idea of the argument. The second best attack is on the analysis of the argument, and only after that, the attack on the evidence of the argument. Ask yourself, is the evidence indicative of well-made analysis? Does the analysis really support the idea? Is the idea really the important part of the debate? Those questions are often more important than, is this example true? Which tends to be how people are bogged down with respect to these sorts of debates. And the second thing to say about examples in these debates is the clarity with which you think about the structure of the debate is much, much more important, and your adjudicator will thank you. Very often what happens in these sorts of debates is one or two examples start the debate, and then the entire debate is just drawn into those examples. Don't let that happen, and if you see it happening, be prepared to step back, be prepared to extract yourself from that, because very often those examples don't prove as much as people think they do. So let's do the basic first principles of Supreme Court before we get into the examples and how you might look at them, because understanding the structure of the debate is going to be much more important than understanding those examples always. And the basic first principles here is to think about outcomes as a result of process. These are the most simple burdens that you have. What outcome do we want? How does the process lead to our outcome? Always focus your analysis on those questions. If you're in the debate and you don't know quite what the context is or quite what's happening or all the case law that's being cited, whatever, don't worry about it. Only worry about what is the outcome that we want for this Supreme Court and what is the process that we are going to use to get there. Those are the things that you should focus all your time and energy thinking about. The rest is mostly just fluff. Most versions of this debate will agree on the goal of the Supreme Court, which will be establishing and protecting progressive rights in some way. A useful thing to have on hand is just a list of upcoming things that we think might be important for the Supreme Court that you can cite if you ever need to just prove that control of the Supreme Court is an important value of the debate and why it is that we're having the debate at all. So for example, employment and discrimination law against LGBT people is an important protection that is constantly in jeopardy. The Commerce Clause and Obamacare and whether or not healthcare can actually be provided by the state to all of the people that Obamacare tried to expand that to through the individual mandate. Upcoming cases about rights to digital privacy and surveillance are always going to be relevant because we don't really know what the Constitution envisages as the right to privacy in an online space because the founders could not possibly have imagined that. The protection of the electoral process and fairness in the elections is always a constant threat in the Supreme Court. And looming above all, of course, is Roe v. Wade and the right for women in the United States to seek an abortion. The overturning of Roe v. Wade will result in deaths, thousands of deaths, very, very predictably. These are not theoretical, they're not abstract, and they're not far off. That's why it's important that we control the Supreme Court. So have a spiel like that prepared, because every now and then it's going to be a really easy way to get points in your introduction or a really easy piece of context setting that tells you why it is the Supreme Court is important. So let's think about how we might contest the outcome, because not all the time is the outcome of we just want progressive social change going to be the thing that you want out of the Supreme Court. Contesting that outcome at the level of do we want progressive change from the Supreme Court is basically contesting that SCOTUS is not the appropriate forum for advancing civil rights, that instead civil rights need to come from Congress or should be decided by elections or by vigorous national debate rather than by 9 justices sitting on the court making a decision about what your rights are. Because when they do that, it's seen as being undemocratic, it's seen as being illegitimate, and it's seen as inviting backlash. And here you just import in all of your backlash arguments that you've all been practicing because they're extremely common in debating, and you'll have done a billion of them by now. One of the things that you need to do here is portray discrimination as happening in ways that cannot be affected by the court, and that discrimination is comparatively the most important way in which discrimination happens. And in a lot of ways, when you're contesting this sort of outcome, what you're contesting is the idea that the ways in which discrimination happen are more important when they come from individual people in your workplace rather than the structures of the law. So instead of coming from whether or not the law can allow for you to be fired by being LGBT, it's whether or not you're provided advancement in your career because of the way people treat you in your workplace, whether or not you're shut out because you know you are being shunned by people in your workplace. It's the way people might campaign, the way people might talk about you. Those are the relevant things, and the Supreme Court in reality has very little power to change those things. And so inviting backlash for entrenched legal rights might not be the trade-off that we want in the debate. On the other side of that, why would we want the Supreme Court to intervene in order to protect those rights? Well, perhaps democratic processes and other processes in that vigorous national debate has failed it has failed to make those sorts of protections, and therefore the Supreme Court is the last resort for how we might get them. But also, well, the other side of that clash is substantive legal rights are the most important. Yeah, my colleagues might hate me, and I will console myself with the monies that I earn by doing my job and being protected in that job. And the protection against housing discrimination, the right to go into a hotel and not be discriminated against because of my race, for example, those things might provide me more security and more sort of might make my quality of life higher than the sort of more nebulous ways in which discrimination might happen otherwise. So perhaps those legal rights are more important. You also might want to contest the backlash argument. You might want to contest that backlash won't be so bad because the Supreme Court acts as a way to set the norms of the nation. And maybe the way people talk about marginalized groups follows the Supreme Court rather than the other way around. And so the Supreme Court might be the institution that's most important to control there. So that's how you might defend the Supreme Court as the appropriate venue for the advancement of civil rights. A second level of outcome, or a second way that we might contest outcome, is where we concede we want progressive rights out of our court, but we don't know what sort of court most protects those civil rights. And so what we want to decide is what that character of that court will have to be to protect those civil rights. And does precedent in particular help or hinder our goal? So precedent is the continuing respect for previous decisions made by the court. You want to construct a spectrum about how far you want that court to defend precedent, and you want that court to abide by previous decisions versus you want that court to make new law, make new decisions, make new interpretations of the Constitution to advance civil rights. So perhaps you might prefer judges who will ignore previous decisions and craft new rationales and new interpretations of the Constitution, i.e. that Constitution would apply to gay marriage or LGBT protection in employment law, these sorts of things, because you think that the role of the court and the outcomes you want from the court are going to be to advance those things. And in order to do that, they need to overturn previously established law. Or maybe you think that the way to protect LGBT rights or the rights of minorities in the United States is to have justices on the court who will respect precedents already in place, who will respect Roe v. Wade, who will respect decisions with respect to the way Congress apportions districts based on population, which is not established in the Constitution. So there might be ways in which you would contest whether or not you want precedent to be the outcome that you want in the Supreme Court because you don't think it will lead to, or do think it will lead to, the protections of progressive rights that the other side thinks. Do you think it's helpful to portray backlash as symmetric, like conservatives are going to hate any kind of change in favor of progressive rights, whether it comes from the court or not? Possibly, but what you need to do is on the side that's saying backlash will be extremely impactful, you need to find that distinction, right? You need to say that there is a distinction between when it comes from the court versus when it comes from national debate. Particularly in the United States, one of the ways that you can do this is saying that the court, by being a federal institution imposing law on all the states, is seen as being very, very anti-states' rights by the conservatives. And the conservatives often don't necessarily want to outlaw gay marriage across the land. Sometimes they do, but sometimes what they want is for each individual state in the United States to have its own debate and to make its own decision. So states' rights are very important in the conservative mind in the United States. And by trampling on that, you fire up that base, you fire up their political rhetoric, you make them more likely to speak out, to fundraise, and to vote in elections in ways that you might not like. So obviously, you can portray it as symmetric, but the task of the team making the backlash argument is to demonstrate why this particular thing results in backlash in a new or more visceral way. So, as I was saying, For the second level of outcome, we want to establish a spectrum. How much respect for precedent do we want these courts to have? And is there a particular type of precedent that you think they are going to respect as a result of our process? And how much precedent and what types of precedent would those be? This gets on to whether or not judges should be responding to public opinion and whether or not they can. Should judges be updating their understanding of the Constitution based on what the majority public understanding of the Constitution is or not? And can they? Can judges understand what public opinion is? They're often a very particular type of person. They're a judge, they've gone to law school, they're wealthy, they're in political life. Is that an appropriate job for them? Is it something they have the capacity to do? Or is updating laws to public opinion the job of the legislature and the executive and not the job of the judicial branch? The job of the judicial branch is to respect the Constitution, to make sure that everything that comes out of the legislature is in line with the Constitution. And if it's not, to tell the legislature to get their act together and create an amendment. This brings us to outcome 2.5, constitutional interpretation. So there are two major schools of thought about how Supreme Court justices should treat the Constitution. This is obviously a simplification of very complex judicial philosophies, but essentially they are constitutional originalists and the living document interpretation of the Constitution. So the constitutional originalist idea is the conservative favored idea and the precedent favoring idea, which is the idea that the Constitution should be interpreted as it was literally intended by the founders. And so if there's a question about whether or not the Constitution applies to something like digital rights to privacy, well, the founders never considered rights to digital privacy, and therefore the Constitution is silent on that, and the government shouldn't make laws that try and infringe on that. Or you could argue that there's nothing in the Constitution that prevents the government from making laws that would infringe on somebody's digital privacy, and therefore their decision-making falls in that particular direction. The opposite of that is the living document idea, the idea that the Constitution should be constantly reinterpreted based on new situation and a changing world. This is essentially how the liberal arm of the court reads the Constitution. They read new rights into it that might not be literally meant by the text, but exist in a sort of nebulous sphere of how we might interpret that text as how it could possibly be interpreted with respect to new rights. So for example, the Fourth Amendment is the protection against unreasonable search and seizure. And it says that the government shouldn't have an unreasonable search or seizure against persons, houses, papers, and effects. And it enumerates those: persons, houses, papers, and effects. Are your online conversations a person, a house, a paper, an effect? Well, conservative justices would say, no, they're not. That's not what the Constitution says. And so therefore, the government can wiretap your online conversations whenever it likes. The liberal justices would say, well, that's clearly silly. Obviously, the founders could not possibly know what an online conversation is or could look like. They had no concept of wiretaps because telephones didn't exist. Therefore, we should read this list, persons, houses, papers, and effects, as being non-exhaustive and therefore extending to new things like your online conversations and recordings of your online conversations. So that's how those judicial philosophies might have different interpretations. Is it possible to, in debating context, to be a constitutional originalist? Well, possibly, and it might be an interesting extension idea. I think it will be difficult simply because progressivism very often wins debates. So it will be hard, but it is an option that's available to you, and it's important to understand why Supreme Court justices are making certain decisions and what we might want out of those decisions. Okay, third type of outcome that I want us to highlight here, and third way to contest the outcome side of this debate: judicial independence. We want the court to be separate from other branches of government, to act as a limiting factor on the power of those other branches. So when the executive passes an executive order or implements new policy, or Congress implements a new law, we think that the judiciary should act as a check on whether or not that law is just. And the most important way that they can do that is by being as different from those branches as possible. That's why we want lifetime appointments. That's why we want a non-elected judiciary. That's why we want there to be a timeline gap between the president who appoints a justice and when that justice might be retiring, so that there's a very different political makeup of the court as opposed to the other branches of government. Because what that means is that the government always knows that when it is creating that policy, it needs to pass constitutional muster. It needs to be argued very, very carefully. It needs to be worked out very, very carefully. Because if it's not, then the court might strike it down. And simply the difference between the courts and those other branches of government is enough to have that effect. And so we want it to be as different as possible. Question from the chat: is it likely we'd ever be placed in debate that forces us to take the originalist standpoint? I think it is entirely possible for someone to set a debate that's essentially we prefer constitutional originalism over the living document interpretation. I'm fairly certain I've seen that on a list of topics, particularly if you're in a topic in America or a tournament in America. Online debating makes this more and more possible. I don't think it's an inherently unreasonable stance to take. So it is possible. Even if it isn't, be aware that you want to set up for your adjudicator that you prefer justices with the living document interpretation. And because you prefer justices with that living document interpretation, you would change the process of appointments in such a way as to create those justices, or to make it more likely that those justices would be in place. So that's outcomes. So these are the three areas of outcomes that you should be focusing on and should be relatively clear to you when you have your debate. You should know what you want out of this and be prepared to defend out of these three outcomes, and be looking for your opposition to contest on one or all of them. Should or should not, the Supreme Court should or should not be the place where rights are protected. Secondly, how much do we want the court to follow precedent? 2.5 is the Constitution a living document, sort of sub-point to that. And third, how independent do we want SCOTUS to be from the other branches of government? These are the big questions that you want as outcomes for your debate. So let's think about process, and let's first look at the status quo of how justices are appointed. There are 9 justices on the Supreme Court. Justices have a lifetime appointment. They are replaced on death or retirement. The president nominates a replacement. So the president just says, I nominate X person to be the replacement. And then the Senate confirms or denies that replacement. The Senate often holds hearings, by which I mean they always hold hearings. They question Supreme Court candidates very, very carefully. They often take the duty to vet Supreme Court candidates very, very seriously, far more seriously than other types of appointments. So the Senate does decide not to confirm appointments even by presidents of their own party if they feel that that person is inappropriate or unqualified. I'll get to some examples of that as we do the history of the Supreme Court section a little bit later. So the Senate questions them and then votes to confirm. The only way to remove a Supreme Court justice outside of their death or retirement is through impeachment and conviction. So impeachment would be a vote in the House, so the lower house, the House of Representatives, and then a conviction in the Senate. There has only been one instance of a Supreme Court justice being impeached and they weren't convicted, and that was in like 1800. It is obviously not a common thing and does not happen. So when we think about how we want to talk about the process of appointments to the Supreme Court, or how the Supreme Court operates, all of those lovely debates that I highlighted earlier, the process debate is centered around stakeholders and analyzing the incentives and the ability to influence the process by those stakeholders. Question from the chat. What happens if a justice gets dementia or something? Is there a way to remove them? As I said, conviction and impeachment. That is the only way that that can happen. Second question. The originalist argument can still improve human rights, which was basically a Consti assignment. I mean, it can. It depends on whether or not you think that the original rights in the Constitution are sufficient, and whether or not you think that they need to be expanded upon. This is going to be part of your decision making and your strategy in the debate. So the most important thing for your understanding of first principles in the process half of this debate is your stakeholders, how you break up your stakeholders, and how you talk about them. Let's do a couple. So how do presidents view these appointments? Appointments to the United States Supreme Court are the most often the most lasting thing that a president will do. It also can affect their short-term policy. So if, for example, you are President Obama and you want Obamacare to be passed and to not be struck down by the Supreme Court, perhaps you would appoint justices or nominate justices who would support your particular interpretation of the Commerce Clause that allows for the individual mandate of Obamacare to survive its challenges in the Supreme Court. But very often presidents treat this as an extremely important thing. It is very often the most important thing that they do in terms of the lasting rights and changes that happen to the United States. Presidents often have a short list of candidates that they would consider were a Supreme Court position to open up. This is more common on the conservative side. So Donald Trump originally had a list of 25. He recently added about 20 names to that list before the death of Justice Ginsburg. But he essentially has a list of people that he would consider appropriate for the US Supreme Court. But maybe if there were term limits, or maybe if the presidents no longer had this power, or the power to confirm was changed in some way, this would change how they make the decision of who they put on that short list, of the sorts of vetting that they go through, about whether or not they consider this appointment particularly sacred or particularly lasting. Now we might think about the Senate. How seriously do the Senate take the qualifications of a candidate as opposed to simply the ideology of the candidate? Do the senators simply think, well, this person's a conservative, they'll have a conservative view of the Constitution, therefore we as conservatives, and there's currently a conservative majority in the Senate, we as conservative like them? Or do they seriously question the qualifications? Do they ask themselves, has this person had experience as a judge? Have they decided constitutional questions previously? Do they understand constitutional questions? And if so, maybe they should be appointed. And if not, maybe they shouldn't be, even though we might agree with them on the ideology. And if we would change this process in some way, or if we as a political actor would lobby in a certain way, maybe that would change their incentives. Then there might be a difference in how the political parties as a whole treat these things. How do political parties maintain political capital for an appointment should one open up? How do they change their voting behavior or their lobbying behavior? How do they change how they run advertisements as a result of a Supreme Court vacancy in particular systems? And in particular processes? Ask yourselves those questions. In terms of voters, when a Supreme Court vacancy opens up, who gets inflamed? How and why? Can we divide this stakeholder up even further into liberal voters, moderate voters, conservative voters? Do all the things that you should be doing when you're talking about voters and their political incentives and how they're going to operate, because those are the things that might change how a senator would vote, or change who the president might appoint, or change whether or not the president might hold a Supreme Court seat open. How does this change corporations and lobby groups to pressure for their particular type of appointment, or their particular issue to be the thing on a president's mind when that appointment happens, especially on the Senate or president? But also, how do they submit briefs as friends of the court, where they try and influence the court decision itself by providing information to the courts on particular issues. How might this affect claimants to the court? So claimants are the people who come before the court, and it's important to understand who that is. So in the United States Supreme Court, you are required to have standing in order to bring that case. And the Supreme Court can't just decide to take any issue that it wants. So the Supreme Court can only take up cases that have already existed, so that have gone through the lower courts in some fashion, and where there has been a harm to an individual who is bringing a suit in order for there to be a redress of that harm. This is different to some other courts. So for example, the Indian Supreme Court, if a justice on the Indian Supreme Court reads about an injustice in a newspaper, they can decide to issue a decision on that injustice without anyone having brought a suit against it, without there being any tangible harm. So they have more power in that way. The US Supreme Court cannot do that. They have to take up cases that are already existing and where there is someone who has been tangibly harmed by a law. Maybe we would change that in some way. Maybe that would change who the claimants are. Maybe another part of the process would change who wants their case to be brought before the Supreme Court, and so who would petition for a Supreme Court hearing on their case. How would this then change the lower courts? Would this change in policy, whatever it is, change how the lower courts decide cases because they know that the Supreme Court will act in a particular way as a response to that change in policy? How would this change how policy is crafted? Would policy be crafted in a different way if the Supreme Court was able to be stacked by one party or another? Does that mean that government would be more efficient because they can get more things through the process? Or does that mean government would be more accountable because they couldn't get things through that process, and so they're more cautious in the types of policy that they pursue? The stakeholder that I want us to focus on, though, specifically, is the judges themselves. What do judges want? Characterizing what judges want and how they go about getting that is an extremely important part of these sorts of debates. Judges might care about their legacy, about the sacredness of their institution. So for example, the Supreme Court is famously very collegial. In spite of the enormous ideological differences between the justices, they maintain friendships across ideological lines. They are unanimous far more often than they are close. They are all united by their respect for the Constitution and each other. So for example, Justice Ginsburg, head of the left-wing arm of the court, and Antonin Scalia, the firebrand crazy nutjob conservative, were extremely close friends throughout their time on the court. And you can see them giving talks together and giving interviews together. There are lots and lots of things online where you can see Supreme Courts talking about their life in the Supreme Court. They have enormous amounts of respect for each other. And as a result of that respect, maybe that creates a good environment for the court. But maybe that's not what the thing that they want or care about. Maybe they want to make a political point. Justice Scalia is probably the most prime example of that in recent times, who had a very, very hardline conservative viewpoint. He would often write extremely controversial dissents to opinions. So judges, when they disagree with an opinion, have a right to dissent and say why they dissent. And they often provide quite extensive rationales for that, some of which are very interesting to read. And if they want to make a political point, then maybe they should be political appointees because they're making political points anyway. But there's also reason to believe that there is a lot of vetting through the party and who the parties appoint to the lower courts, especially in recent times. And the reason for that is because very often in the past, judges have not turned out the way that the party that appointed them might have wanted them to. And we're going to talk about some examples in part 2, which should be getting on in a second. The other thing to think about is, what are the backgrounds of justices? They're probably politically active. They're probably rich. They've probably been judges for quite a long time. Does that change how they think about things? And is there a way that we could change the process in order to change who justices are, and how would that change what their interpretation of the Constitution would be, and how would that change the outcomes that we want for the debate? So that's the first principles section of things. Now we get on to the abridged history of SCOTUS. Question: typically, how old are justices when they are appointed? I don't know of any judge who's been appointed before their 40s, but they're typically 40s or 50s. A president would like their justices to be on the court for a long time. I think Justice Ginsburg was in her 60s when she was appointed, and it was argued at the time of her appointment that she was too old and she wouldn't be on the court for very long, and that was all very sad. And 28 years later, she was still on that court, and she did last for a long time. But as a result of medical technology, justices are having longer and longer terms, and that might be an issue that you also think is important context. So, abridged history of the Supreme Court of the United States. There is an infinitely Googleable list of things. Apparently, the youngest Supreme Court justice was 44. Somebody has Googled very, very quickly on the point, so thank you, James, for that. The Supreme Court and its decisions are infinitely Googleable. There is a huge number of controversial decisions that they have made. I will be talking about the most important ones, or at least what I think are the most important ones to know for a debating context. First, Dred Scott v. Sandford. So this was an 1857 decision. It was decided 7-2. Dred Scott was an enslaved black man. He was enslaved in Missouri. His owner had brought him into Illinois for a period of about 4 years, which was a free state where slavery was illegal. He sued for freedom on the basis of, well, when I entered Illinois, I became a free man. The court in Dred Scott ruled that he couldn't sue because the Constitution does not consider African Americans or people of African descent. That term obviously hadn't existed yet. The Constitution does not consider people of African descent to be persons. And because they're not persons, because they're not citizens, you can't sue. You have no standing. You have no rights. This was before the Civil War. It was only a few years before the Civil War, and is seen by many as hastening that Civil War, because obviously the reaction in the free states was, this is insane to decide that African Americans are not human beings in this way. And it was seen as being an extremely partisan decision. The court made that decision in large part because they thought it would be a compromise that stopped the Civil War, which everyone knew was coming, from happening. They were incorrect. The Civil War happens. It is the worst decision the Supreme Court has ever made by a long shot, and the Supreme Court should be ashamed of it and has been ever since. It was nullified after the Civil War by the post-Civil War amendments, especially the 14th Amendment that said everyone born or naturalized to the United States is a United States citizen and shall have the rights of the United States citizen. So that's Dred Scott. Next part of history, the New Deal. So the New Deal was a package of legislation created by President Roosevelt, essentially in order to recover from the Great Depression. It would entrench workers' rights. It included things like minimum wage. It included provisions for unions, a huge package of reforms. It also included quite a lot of like social welfare reform and legislation. The Supreme Courts were just like, no, this is not a thing. The Constitution does not provide for the federal government to tax people for the purposes of Social Security. It does not provide for the federal government to make limitations on wages or working hours in the way being described by the New Deal, and so was striking down huge portions of New Deal legislation. President Roosevelt attempts to add new seats to the courts. His proposal was that President could appoint up to a maximum of 6 extra justices to the Supreme Court, 1 for every justice over 70 years old. 70 and 6 months was, I think, the cutoff. So And it's important to note that the limit of 9 justices is only a legislative limit. That's not in the Constitution, and so can be changed just by an act of Congress. A few weeks after Roosevelt begins to push for this, the court suddenly has a change of heart on New Deal legislation, starts upholding that legislation. Gosh, I wonder what that could have been. So apparently, the court decided that its judicial philosophy was a little bit more flexible than they had previously as a result of political pressure. So that's a very interesting example of where political pressure might influence a judicial process and how judicial independence might be stymied in certain ways. The reform ultimately did not pass, probably because it was held in committee for like half a year. But this plan, the idea of expanding the Supreme Court, has been suggested as a possibility for Democrats after the 2020 election, if Donald Trump appoints someone to replace Ruth Bader Ginsburg. Next piece of history, the Warren Court. So Earl Warren was a Republican governor. He'd run for vice president on the Republican ticket. He'd tried to run for the presidential nomination for the Republican Party. Hardcore Republican, appointed to the court by Dwight D. Eisenhower as the Chief Justice. So the way Chief Justice is determined is there is a Chief Justice. When they retire or die, whoever replaces them is the new Chief Justice. So it's not like a seniority thing. It's just whoever replaces that one person. And the period of their tenure as Supreme Court Justice, or Chief Justice of the Supreme Court rather, is named after them. So Earl Warren as Supreme Court Justice is the Warren Court. This lasts from 1953 to 1969. Every liberal reform, every left-wing reform that you have ever heard about from the Supreme Court comes from this period and is orchestrated by Earl Warren, the Republican Supreme Court chief. They ended segregation. They established Miranda rights, required equal populations for congressional districts, upheld the Civil Rights Act, made the Bill of Rights apply to state and local governments, created the right to privacy. They struck down laws against interracial marriage and restricted the ability for public figures to sue for libel. Most of these decisions remain in force. All of them are Googleable, all of them that you can look at. What powers does a Chief Justice have that other justices don't? I honestly don't know. I suspect they are mostly procedural things. It's still one vote.
There's things like picking which cases the court's going to hear. There's a Wikipedia article on it, which I suggest you just Google that. But it's not just there are some powers to it. It's not purely a position and a title.
Thank you, Peter. So yeah, the Warren Court, in spite of being Republican appointed, is extremely, extremely liberal and is an enormous outlier. For most of the court's history, the court has been conservative. It is conservative before the Warren Court and has been shifting more and more conservative after the Warren Court. So in terms of characterizing the history of the court, maybe it's not the bastion of rights that we might sometimes imagine. One of the most important decisions that they made was Brown v. Board of Education. This was a 9-0 1954 ruling that ruled that segregation was unconstitutional, that separate educational facilities are inherently unequal. And this is based on the Equal Protection Clause, which reads, "Nor shall any state deny to any person within its jurisdiction the equal protection of the law." This was overruling a previous decision that had stood for 50 some odd years, that established the idea that it's okay for there to be separate facilities for people of different races so long as they are of equal quality. But as we all know, that was not really what was happening in the segregated South. The facilities were not of equal quality. The decision in Brown v. Board of Education caused a massive backlash in southern states, a campaign of massive resistance, which you can all Google. This is all just a list of things to Google. The next important decision, and the most controversial and the most important decision to have some knowledge about, is Roe v. Wade, a 1973 decision, a 7-2 decision. This happened after the Warren Court, but was based on a decision made by the Warren Court. And this established that a pregnant woman has a right to seek an abortion without, quote, excessive government restriction. What that might be is not clearly defined, and that this was founded in the right to privacy in the 14th Amendment. This was, again, a post-Civil War amendment. this right to privacy is not actually in the 14th Amendment. It's not in any part of the Constitution. It is inferred to exist by the Warren Court in a case involving contraceptives. So whether or not the states can make a law that prohibits married couples from seeking contraceptives, the Warren Court decides that there is a right to marital privacy. And in that case, the 7-2 majority found that a right to privacy existed, quote, in the penumbras and emanations of the Bill of Rights. Penumbras and emanations is a somewhat vague term. It exists in a sort of interpretive reading of it. It flows from the Bill of Rights, even though it is not within the Bill of Rights. So legally, Roe v. Wade might be on quite shaky grounds. And that's one of the reasons why conservatives contest it so much, but has also been contested because it was seen as a very, very easy issue to rile up a Republican evangelical religious base for Republican voters. It's been upheld ever since with some modifications to what excessive government restriction might mean, but it is extraordinarily controversial. Conservatives treat this as, and the way they describe it is the genocide of the unborn, and they treat it with the moral seriousness of the murder of hundreds of thousands, if not millions, of unborn children. And what that means is abortion clinics, especially in the South, are constantly under threat from legal restrictions. So, for example, the requirement that they have admitting privileges to other hospitals, or the requirement that there be certain types of doctors on staff. Southern states are always testing the excessive government restriction provisions, but also physical violence has been extremely common against abortion clinics. Things like being bombed, things like the doctors and nurses working there literally being assassinated. There are almost constant protests outside known abortion clinics where people are trying to dissuade people from getting into those clinics. Republicans treat this as the most important electoral issue to ever exist anywhere. Interestingly, at the time of Roe v. Wade, it was not seen as being that controversial. This was something that was in many ways engineered later by the Republican right, looking for an issue that would fire up their base. Again, infinitely Googleable. There is an enormous amount of history over these cases and over the outcome, particularly of Roe v. Wade. Next piece of history, Bush v. Gore. So in the 2000 presidential election, it all came down to Florida, and Florida came down to only 1,000 or 2,000 votes. The Democrats decided, well, Florida law allows for us to have a recount when it's this close. There is an enormous amount of controversy over that recount because honestly, going into this would take too much time, and I'm over time already. Google this as well. It's a really fascinating read, but essentially the recount takes so long and is challenged in courts in all sorts of ways that it eventually makes it to the US Supreme Court whether that recount should continue and under what provisions it should continue. The Supreme Court begins by halting that recount for about 8 days while it decides. So it says you cannot continue the recount until we decide if you're allowed to continue the recount. After that 8 days, they decide that the recount as it is being conducted is unjustified because there are different ways in which the recount is happening in different counties, and therefore that violates the Equal Protection Clause. And it decided that there is not enough time before the certification deadline where the Electoral College would meet and decide the next president for there to be an alternative to those mechanisms in the recount. The reason there wasn't enough time was because they had halted the recount for 8 days. But that notwithstanding, they have now decided that George Bush is going to be president in spite of an ongoing recount that at the time of being halted, the difference between the two candidates was like 300 votes. That's how close that presidential election was. It is unclear what the legal basis for their decision was, and they decided that they would limit the decision to the present circumstances, something that they have never done in the history of the United States. So if you're looking for how the influence of politics might go the other way, in the year 2000, the Supreme Court just decided who the president was. They literally just made that decision. on the basis of extremely shaky legal grounds. Okay. Next piece of history that you should know about is Citizens United versus the FCC. This establishes that the First Amendment prohibits the government from restricting expenditures for political communications by corporations. Essentially, money is speech and corporations are people. Therefore, the right for people to use their free speech means that corporations can spend as much money as they like. That is obviously a simplification, but it has in many ways been seen to lead to the current amount of what's called dark money in United States politics, which is money that's sort of untraceable and that funds their like multi-billion-dollar elections. It has been contested whether or not Citizens United was the important case, or whether other precedents earlier had established enough law already that something like Citizens United was legal. So bribery is not illegal under these, is not legal under these decisions, but is very, very carefully defined. So the corruption that the court cares about is only explicit quid pro quo corruption. And if it's not explicit quid pro quo, if no one literally says, I am giving you this money in order for you to deliver a certain policy outcome, then it's not quid pro quo, it's not corruption, and is therefore legal. That again is a slight simplification, but that's basically the status quo of the United States. Next piece of history, and this is where we're getting onto the appointments process, which is the appointment of Neil Gorsuch. In 2016, Antonin Scalia dies. He dies very early in the year, February 13. Obama nominates Merrick Garland and the Republican Senate simply refuses to hold a hearing on it. Not even a vote, just never even a hearing. So they leave the seat open for 400 days. Scalia was extremely conservative. His replacement by a moderate or liberal would shift the balance of the court, would shift the interpretations that court made. This happened very soon after SCOTUS had made a ruling on gay marriage, which was in 2015, and where they had ruled that gay marriage would be legal in all 50 states via the Equal Protection Clause again. And so conservatives were already very fired up about the US Supreme Court. There are a lot of very relevant to the present circumstances quotes that you can look up. You can see Lindsey Graham saying presidents should not appoint a justice in the final year of their term, and that he invites the Democrats to use that quote against him if Donald Trump tries to nominate someone in his final year. There are also quotes where the president of the Senate, the Republican president of the Senate, said they can't appoint anyone because Obama would only nominate a liberal judge and not someone moderate like Merrick Garland, literally naming Merrick Garland, who Obama then nominates and the Senate refuses to hear a hearing on. And so the Senate holds the seat open for an unprecedented amount of time. Neil Gorsuch is appointed in April after the election of Donald Trump. The appointment of Brett Kavanaugh, this is in 2018, is extremely controversial. He was accused of sexual assault by Christine Blasey Ford based on an encounter when both were in high school. He is accused of a number of other women of sexual assault, with some recanting and others not holding up to scrutiny, others still maintaining their position. Christine Blasey Ford is invited to speak to the Senate, and Brett Kavanaugh to speak after her to defend himself. It causes an enormous amount of division in the Senate. It's seen as being highly partisan. Kavanaugh, in his defense, calls it a political hit by the left, which Chief Justice John Roberts then organizes for an ethics investigation into Kavanaugh for that. He has ethics complaints brought against him because of the statements he makes in his defense, but those complaints are dismissed once he becomes a Supreme Court justice, because lower court justices aren't allowed to investigate Supreme Court justices, or at least so they have decided in this particular case. Conservatives in the United States literally think that her accusation was a false accusation orchestrated by the Democrats, orchestrated by Adam Schiff and other Democrats in the House and in the Senate in order to create division about Brett Kavanaugh's appointments, to rob Donald Trump of his ability to appoint Brett Kavanaugh. That's literally what they think. And that leads to the current political climate around Ruth Bader Ginsburg, sometimes called the Notorious RBG. Ruth Bader Ginsburg was the second woman appointed to the court after Sandra Day O'Connor. Sandra Day O'Connor was nominated by a Republican. Ginsburg, for a few years after Sandra Day O'Connor retired, was the only woman on the Supreme Court. She is now one of 3 women on the Supreme Court. As a lawyer, she had argued landmark cases for women's rights, interestingly, often taking the side of men who had been the victim of gender discrimination in order to create the legal precedents that she would then use to argue that the Equal Protection Clause applies to gender. She was appointed by the Senate 97-3, so a nearly unanimous appointment, something that's almost impossible to imagine in the current state of disputes around Supreme Court justice. She was seen as a moderate when she was appointed, but sort of became the left wing, especially after the retirement of Sandra Day O'Connor, but simply as she has gained seniority on the left. She died September 18th of this year, only a week ago. The conservative reaction that I have seen has been mostly jubilant, but also gearing up for a political fight. The posts on R Conservative on Reddit were essentially good because she hated the Constitution, right? That's the way that she is being seen by the conservatives, and that the conservatives really want someone who will overturn Roe v. Wade as her replacement. And so her replacement by a conservative would shift the court on Roe v. Wade and a wide variety of other issues. The most likely candidate to replace her is Amy Coney Barrett. Trump has said previously, or said in response to the death, that he will almost certainly be replacing her with a woman. Amy Coney Barrett is seen as the front runner. She's a devout Catholic. She believes life begins at conception, but she has been vague about how far she would be guided by her faith in her judgments. In her work as an appellate court judge, she's said that she would not seek to overturn Roe v. Wade because she, as an appellate court judge, is bound by the decisions of the Supreme Court. But presumably now that she is on the Supreme Court, or will be if she is nominated and confirmed, judge on the Seventh Circuit since the year 20,176, apparently. You can tell my state of sleep when I was making this slide. But this is the most likely replacement. It's probably worth Googling her and some of her statements. So the last thing is that there have been a couple of failed appointments. Robert Bork and Harriet Mears, again, Google them because I am out of time. This has been my abridged history of the US Supreme Court. Does anybody have any questions before we end the recording?